as stated, are equal before law. But in your instance, it cannot be said that you are not accountable due to the position you find yourself in. You are accountable to members or citizens of this country, to your followers, to the youth. And that accountability stems from your position. And that is where I'm going to end this. You may please stand up. Not the court only. I'm sorry. Maybe I should be clear. Okay. Sorry for that. All right. After careful consideration, and I can show you I have done so, free of any interference, this judgment or sentence is the sentence of this court and this court alone. In respect of count 1, you are sentenced to a period of 5 years imprisonment. In respect of count 2, you are sentenced to a period of 2 years imprisonment. In respect of count 3, you are sentenced to 20,000 rand or to undergo 6 months imprisonment. In respect of count 4, you are sentenced to 20,000 rand or to undergo 6 months imprisonment. In respect of count 5, you are sentenced to pay a fine of 20,000 rand or to undergo 6 months imprisonment. In terms of Section 280, subsection 2 of Act 51 of 1977, the court orders that the sentence imposed in respect of counts 2, 3, 4, and 5 run concurrent with the sentence imposed in respect of count 1. You may be seated. Thank you. May we, Advocate Otis, sorry not to interrupt you, may we just deal with the Section 103 inquiry and then we can proceed to that part? I assume you are ready for that part as soon as we've dealt with the 103 inquiry. Certainly. Okay. Let me just find my notes here. Just as a brief explanation to unless it's not clear, the next step after sentence is that the court is obliged to deal with the provisions of Section 103, subsection 1 of Act 60 of 2000, meaning that the determination of unfitness, as I've explained in the beginning of the sentence, should not be made separately before sentencing, as information relevant to such fitness may emerge during the process of mitigation or circumstances, and the inquiry in terms of Section 103.1 Act 60 of 2000, since in terms of Section 1, the accused is deemed unfit to possess a firearm or license in future by virtue of having been convicted of a crime specified in Section 103, subsection 1 of Act 60 of 2000, and reasons may therefore be advanced or evidence presented to enable the court to consider the possibility of determining otherwise. So, Advocate Otis? No submissions. Thank you. Advocate Caesar, on behalf of the state. Due to the reasons provided by court during sentence and that we are dealing with unlawful possession, due to the virtue of the nature of the offences, the court therefore makes no otherwise order and you remain to be deemed unfit, and it is followed by the following further order by court. that Section 103, subsection 1, read with the provisions of Section 104 of Act 60 of 2000, the accused then remains to be deemed unfit, and the effect of the declaration of unfitness is as follows. All competency certificates, licenses, authorization, and permit issued in terms of this Act to any person who becomes or is declared unfit to possess a firearm in terms of Section 102 and 103 cease to be valid from the date of the conviction or the declaration, as the case may be. B, despite the noting of an appeal against the decision of a court or the registrar, the status of unfitness contemplated in paragraph A remains in effect pending the finalization of the appeal. Further, a person who becomes or is declared unfit to possess a firearm in terms of Section 102 or 102.3 of Act 60 of 2000 must within 24 hours surrender to the nearest police station all competency certificates, licenses, authorizations, and permits issued to him or her in terms of this Act, all firearms in his or her possession, and all ammunition in his or her possession. Therefore, it should be noted that subject to the provisions of subsection 9, subsection 3, subsection B, and after a period of 5 years calculated from the date of the decision leading to the status of unfitness to possess a firearm, the person who became or becomes or deemed and declared unfit to possess a firearm may apply for a new competency certificate, license, authorization, or permit in accordance with the provisions of this Act, being Act 60 of 2000, the Firearms Control Act.
An application for leave to appeal to the High Court of South Africa, East Cape Division, held at Grahamstown, against the arm of the judgment convicting the accused of firstly unlawful possession of a firearm in contravention of Section 3 of the Firearms Control Act 60 of 2000, to wit a .223 Narinka rifle and or a firearm the make of which is unknown to the state without holding a license, permit or authorization. The second count, Your Worship, that we seek leave to appeal against is unlawful possession of ammunition in contravention of Section 90 of the Firearms Control Act 60 of 2000, to wit a .223 Remington bullet without holding a license, permit, dealer's license, manufacturer's license, gunsmith's license, import or export or transit license, or other authorization to do so. The third count, Your Worship, is unlawful discharge of a firearm in a built-up area or any other place in contravention of Section 120 sub 7 of the Firearms Control Act 60 of 2000, to wit the CISA Kakashi Stadium in Nansani. The fourth count, Your Worship, is unlawful failure to take reasonable precautions to avoid danger to personal property in contravention of Section 120 sub 3 sub C of the Firearms Control Act 60 of 2000, in that the accused of control of a loaded firearm, to wit a .223 Narinka rifle and or a firearm the make of which is unknown to the state, in circumstances where it created a risk to the safety or property of the general public, attending the 5th Economic Freedom Fighters celebration. And finally, the fifth count, Your Worship, is reckless endangerment to a person or property in contravention of Section 120 sub 3 sub B of the Firearms Control Act 60 of 2000, in that the accused unlawfully discharged or otherwise handled the firearm, to wit a .223 Narinka rifle and or a firearm the make of which is unknown to the state, in a manner likely to injure or endanger the safety or property of the general public attending the Economic Freedom Fighters celebration, residents of Ndansani and the employees of Gear House, with reckless disregard for the safety or property of the general public attending the 5th Economic Freedom Fighters celebration, the residents of Ndansani and Gear House employees